What is a charge? Explain its meaning and object. A charge is a formal accusation made against a person who is alleged to have committed an offense. It is a written statement prepared by the court specifying the offense with which the accused is charged. The purpose of a charge is to inform the accused clearly and precisely about the nature of the accusation so that he can prepare his defense effectively. In criminal trials, a charge forms the foundation of the prosecution case and ensures a fair trial by preventing surprise or prejudice to the accused. Legal provision. The provisions relating to charge are contained in Chapter 17, Section 234 to 250 of the BNSS 2023. Section 234 Contents of charge. Section 235 Particulars as to time, place, and person. And Section 236 when the manager of committing offense must be stated. These provisions require that the charge should contain sufficient particulars regarding the offense alleged against the accused. Essential features, conditions, contents. The following are the essential features of a charge. Written statement. A charge must be in writing. A specific accusation. It must clearly specify the offense alleged. Legal description of offense. The offense should be described using the legal terminology provided by law. Particulars of time and place. The charge should mention when and where the offense was committed. Information to the accused. It must provide adequate information to enable the accused to prepare his defense. Fair trial safeguard. It protects the accused from prejudice and ensures procedural fairness. Explanation. The concept of charge is based on the principle of natural justice that no person should be condemned without knowing the allegations against him. Before evidence is recorded, the accused must be informed of the exact offense for which he is being tried. A properly framed charge serves several purposes. It informs the accused about the precise nature of the accusation. It enables him to prepare his defense effectively. It helps the court identify the real issue in dispute. It prevents confusion during the trial. It protects the accused from being tried again for the same offense. A defective charge does not automatically vitiate the trial unless it causes prejudice or failure of justice to the accused. Case law. Willie Slaney versus State of Madhya Pradesh, 1955. The Supreme Court held that an error or omission in framing a charge does not invalidate a conviction unless it has occasioned a failure of justice or prejudiced the accused. Kantilal Chandulal Mehta versus State of Maharashtra, 1969. The court observed that the object of a charge is to give the accused clear notice of the case he has to meet and defend. Importance or significance. The framing of a charge is an important stage in criminal proceedings. It ensures transparency, fairness, and compliance with the principles of natural justice. A properly drafted charge enables the accused to understand the prosecution case and safeguards his right to a fair trial. It also assists the court in conducting the trial effectively. Conclusion. A charge is a formal written accusation against an accused person and is an essential component of criminal procedure. The provisions contained in Section 234 to 236 of the BNSS 2023 ensure that the accused receives clear and complete information regarding the offense alleged against him. Thus, the charge serves as a vital safeguard for ensuring a fair and just criminal trial.